Welcome to this webinar on family law update, some parenting changes that have happened in Australia in 2024. My name is Natalie. I'm from the Community Legal Education branch at Legal Aid New South Wales, and we're very lucky to have Sharda with us today, who is an expert in family law from the Early Intervention Unit at Legal Aid. So Sharda, I'm going to hand over to you to get started. Thanks, Sharda.
Thanks so much, Natalie. All right. Now, as Nat said, we've got a lot to go through today. But before we start, I'd like to acknowledge the Barramadigal, Wangal, and Walyumedigal people, the saltwater people who are the traditional custodians of this land from which I speak to you today. And I pay my respects to the elders of this land, past and present, and extend that respect to any Aboriginal and Torres Strait Islander people joining us today.
Thanks, Sharda. Just another disclaimer, I suppose, before we start. So as usual with these webinars, the information we're giving is just legal information, not legal advice. And also we've noticed there's quite a few lawyers joining us today, which is great. But this webinar is designed for our audience of community workers, so part of our Law for Community Workers program. So there's plenty of professional development for lawyers as well. You're welcome to join us today, but our audience is more support workers and community workers. So I just wanted to make that clear. And we're going to do a very quick poll first. So hopefully that comes up for you. And it's just, what do you think family law is? So what does it include? And I'll give you a bit of a clue that you can click more than one option. So I've just got that poll up. Hopefully you can see that, Sharda. So people are putting in what their thoughts are. Is it parenting and property, marriage and divorce, spousal maintenance and child support, recovery orders, international child abduction and airport watch list? And we've also got AVOs, or apprehended violence orders, on there. So just to give us an idea of what you think family law is, and then we'll hear from Sharda. I'm actually going to close that now because we don't have a lot of time today. And I can share the results with everyone. So what you can see, Sharda, so everyone agrees parenting, property, marriage, divorce is all family law. And most people think spousal maintenance, child support, recovery orders, international child abduction. Half the people think AVOs is part of family law. So I'll stop sharing that now, and maybe Sharda, you can explain what you do in your work and what family law is. Thanks everyone for participating in that.
Yes.
Okay.
So, basically, in the best traditions of pop quizzes everywhere, the answer is kind of all of the above. Because in my mind, what is family law is what a family lawyer does, whatever we advise about. We may have specialties in certain areas. When it comes to AVOs, that overlaps with criminal law matters. But you'll find yourself in family law dealing with matters where people have family businesses. And then you find yourself dealing with taxation and director's duties and all sorts of things. Family law touches on a lot of areas, but what I want to do today is, as Nat said, we're focusing on law for community workers. And I think the relationship that we have when you send a client to a family lawyer to get advice and assistance, what is it that they're going to get help with? What is it that we can do? And how do we build that relationship so that we're all working together for the best interests of our clients? So really, family law covers a lot of things, but what I think most people want to hear about, apart from emergencies where a child is about to be abducted internationally or has been taken by a parent and it's not safe. So those are international child abduction, watch list orders, and recovery orders. I think most people, when they're asking about family law, they're asking about things like divorce, parenting, property, and financial support. That's usually what people want to know about. So I tried to work out what's the best way to give you a little bit of an introduction to family law. Thought back to my uni days, and I thought, no, that's just not going to make sense. Really, I think what will be helpful is if I do a little summary of what I advise clients about when they come to me as a family lawyer. So I've skipped over the part where we talked about what it is that we're going to be doing today, but essentially what I want to do is tell you about what family law is and what it's not. And spoiler alert, it's not like TV, sadly. We don't all wear very fancy suits and have fabulous hairstyles. But, I want to just talk about what it is in Australia, because I think a lot of people actually consume content from overseas and they don't necessarily need to know how Australian law works generally. So that's one thing, a quick review of what family law is, then a review of what the changes are that have come into place earlier this year. So I think that's really relevant because that's the first set of changes and another further set of changes is coming along. So I'll talk about that. And then specifically, the resources that we use and the referral pathways for clients. So how you can get clients to us and what things we can do to help. I think that's really relevant too for you to just have an understanding of how that works. So, like I said, I'm not going to give you the whole family law training unit. You can do courses and classes and take this for months. I'm going to give it to you in 10 minutes. A little summary of just how family law works in Australia based on how I would advise a client who came in to see me. So when a client comes in to see me, one of the things we didn't have on our little poll was the distinction between care and protection law. So that's what we call it here in New South Wales. I know there are some people from interstate watching. You might call it child welfare law. Basically, you as support workers, when you have to make a report, as a mandatory reporter, you may have to make a report to the department about child safety issues. That's what I would call care and protection law, and it's state-based, different from family law, which is federal-based. So each state has slightly different arrangements in different courts. In family law matters, the Federal Circuit and Family Court of Australia is the same court across the country. So first question I usually ask is to find out from a client whether they're actually dealing with the department, because then that's a care and protection matter, which our family lawyers do deal with, or if it's a family law situation where they've had a relationship breakdown or something like that. So we're focusing on the second part. And the big 5 things that people usually want to ask about are divorce, parenting, property, spousal maintenance, and child support. So when a client comes in, they might say to me, I'm not sure why I'm here. My support worker or my psychologist or my friend told me to come. And so I'd explain confidentiality. That's how lawyers will keep everything confidential. And for legal aid, specifically our conflict policy, which means that if a legal aid office is helping one person, I'm in a firewalled unit. So we are allowed to help the other person without there being a conflict of interest. So I'll go into that later. But once they're happy with understanding that, then I'll say to them if there was any specific things that they wanted to ask me about and get them to tell me their story in summary form. So usually they'll talk for a few minutes about what's happened recently. They might start from the beginning. I might get them to skip forward a bit because I'm thinking about big issues like when did the relationship start? When did they get married if they did? When did they break up? What is it that has happened? How many kids do they have? What property do they have? And what is it that they want to do now? Some people don't have that clear. They usually know how many kids they've got, but they might not really know what it is that they want for those kids' arrangements. And so when they come to see a lawyer, usually people are very stressed and anxious, and they don't have a good understanding of what family law is. So I tell them, look, I'm going to tell them about those 5 things to start with so that we're all on the same page. And we can go from there about working out what it is that we need to do next to get them some more help. So the first thing, divorce, I'll explain that unlike America and unlike on TV and movies, in Australia, to get a divorce, we don't look at fault, what happened to cause the relationship breakdown, just that there was a relationship breakdown, which has to be proved by 12 months of separation. So to get a divorce, which legally ends the marriage, makes a person change from legally married back to legally single again, a divorce is not an immediate step. However, that is a paperwork step, an administrative step that will be taken at the end of that 12-month period if they wish, but they can start dealing with property and parenting from now, from the time that they've come to see me. And so a lot of people believe that divorce covers those things and use that word to describe all of the other things. We don't use it that way because divorce actually specifically means that ending of marriage. So that's one thing. When it comes to the parenting arrangements, the update that I spoke about as to how our law has changed in May of this year, there's been a major change to the law. So I'm not going to go too deep into what that is now, but I would explain to a client exactly what that change means for them. They don't need to know what the old law said and what the new law differs. They just need to know how it affects them and how to make it work for them and how they operate under this. So I would explain to them what the law says in terms of the factors that the court considers when making a decision about what's in a child's best interests, and also explain about the process of that. So for most people, it starts with just discussing for themselves. They can try mediation, which is negotiation outside of court. If that doesn't work, or if that's not safe, maybe court is the next option that they need to consider. And do they need a lawyer for that? And things like that. We'll go through those options. When it comes to property, lawyers use the word property to describe basically money things. So it doesn't just mean land, it also means savings, superannuation, and debts, all things of value, and all the liabilities as well. So when lawyers are advising about property, we talk about a 4-step process, even though that's not really strictly accurate. And I will describe in a little bit further down this presentation the proposed changes to the legislation that are coming in as well. But when we talk about property, we really look at what's there to divide. And so people have these really strange ideas usually from movies, I think, or from what they heard their friend got out of their neighbor's divorce settlement. And they talk about things like percentages and who gets what. Really, the way that we look at it in family law is we look at what's there to divide, all things of value and all the debts in each party's name, joint names, and joint names with other people as well. So if there is property overseas, if there's money that's shared with other people, the party's share of that comes in, and we look at what's there to divide, what the contributions have been, both financial and non-financial, throughout the relationship, before the relationship, and even after the relationship ends. So we look at what those contributions can be, and people get a bit confused. They say, oh, I got an inheritance, that's not a contribution. We really consider all the things that have come in and who they've come in because of. And so, if there were things like I helped to build a deck with my brother-in-law because they've got carpentry skills and it could have cost us $20,000, that becomes a contribution. So people's circumstances really dictate how that gets calculated. And then we also look at what the future needs of each person are in this relationship. So whether married or de facto, we're looking at the future needs of each of the parties and whether there should be an adjustment to those percentages based on those future needs, things like health conditions, responsibility for looking after children, things that affect your earning capacity into the future. And then we go back to that pool of working out what was in the assets, that sort of balance sheet at the start, and we divvy it up. We look at what each person should get in a just and equitable outcome. So you can't eat super, you can't live in it, but someone who is getting a division of the assets may actually need to put something towards their future needs, or they may actually need to preserve as much cash as possible for immediate spending possibilities because of their income earning capacity being limited. So that 4-step process is a really it's not something where you can really plug it in. We're not in the AI world yet where you can just type in numbers and the computer will spit out what a settlement is. It really depends on people's circumstances. And so as we advise about that, I also talk about spousal maintenance and child support. So spousal maintenance is not that common in Australia. And when you hear about it, you actually hear Americans talking about alimony usually. So alimony is payments to a spouse to help support their financial requirements and lifestyle. And that's spousal maintenance here in Australia. But we also have child support. So that is based on a government formula. And that talks about what support a child needs, financial support a child needs based on the number of nights they spend with parents and things like that. So people often get them confused, and they often say to me things like, oh, look, I don't want any money. I just want to make sure that the kids are safe and that things work out. But I think it's important for people to be advised about all of this. One of the big things I always advise about is time limits when it comes to divorce or de facto partners separating. There is a time limit to deal with any financial matters. there is not a time limit to deal with kids matters. And we're going to get into what arrangements can happen for kids at certain ages as well in a moment.
And Sharda, speaking of time limits, I'm going to be really mean and say you've got 2 minutes left on your 10 minutes.
In my 10 minutes. Well, like I was saying, when it comes to a client coming in, they often don't know what it is that they need advice on. They might think it's divorce and then hear about that and go, actually, I needed child support. So we talk about that process. We talk about the mediation process as a negotiation stage before court, if need be. And we also talk about if they need other kinds of advice. So like I mentioned, you might have a family business. You might have an investment property which needs to be sold, and then there's going to be capital gains tax. If there's a property that's going to be transferred and you get a stamp duty exemption on that transfer, there are many things that actually impact on a family law matter where a family lawyer might say you actually need to get some other advice. Maybe you've sponsored a spouse or you yourself have sponsored, or there's an AVO or criminal charges as well. So you need some immigration advice or some criminal law advice. So we might say you actually need to speak to another kind of lawyer as well as speaking to us. And we might talk about the non-legal advice that a person needs too. If someone's coming to you for family law advice, or you're referring a client, this is probably one of the worst times of their life. And they may need to actually have some additional supports in place, like a counselor or a psychologist or other health professionals. They may actually have never dealt with finances before for themselves. They may need to speak to an accountant. They may need to speak to a debt counselor. There are a lot of additional services that you might be figuring out as you speak to a client. These are the things that they'll need. So as a family lawyer, those are the things that I'll be thinking about too, and probably making referrals to all of you about. And most importantly, I think for people is how are we going to pay for it? If you need to have a family lawyer, are you eligible for legal aid assistance? Are you going to have to pay for it yourself? Or are you going to have to do this for yourself because you don't fit in either category? So those are the things that we'll talk about in a family law advice session. And I know that doesn't cover everything you want to know about family law, but like Natalie said, we've got a lot to cover, and I'm going to go through a lot more of those things as we go, but I am also happy to take questions as we go too. So I don't want to make you feel, for the people who are not lawyers watching, I don't want to make you feel like you should be giving legal advice because you could get sued. That's what we have insurance for. That's why we do it in the way that we do it. But I want you to understand when a client comes to me that these are the things that I would be looking at and trying to advise them about when they first see me.
And we asked in the poll about AVOs, and I know that a lot of family law clients at Legal Aid do have domestic and family violence situations, and our family lawyers do talk a lot about domestic violence and AVOs as well. So we would count that as part of our role for sure.
Yes, absolutely. Safety planning is a really big thing. And we work closely with the support workers in our teams and in our services where we give advice to make sure that clients get that wraparound assistance. If they need specific advice about AVOs and criminal charges and perhaps even representation in those matters, we might make referrals, but otherwise family lawyers deal with all of those things as well.
Okay, so moving on to the changes, just quickly, Sharda, you wanted to talk about some of the bigger changes before the 2024 specific ones.
Yes. So we talk about the update, the recent update, but I don't think it makes sense without you knowing the context of just a few years ago during COVID times, the courts actually changed their name. So you might have heard of the Federal Magistrates Court, the Family Court. You might have now heard of something called the FCFCOA. Some people have said it sounds like focaccia. It's not half as delicious. It's called the Federal Circuit and Family Court of Australia, which came into being because those other courts merged. And so now it's sort of like a one-stop shop, which it kind of already was, but now it has that name as well. And what it meant is that there are a whole new set of forms, new rules, and a lot of new processes and practice directions. So instructions about how a certain case should be run. So parenting instructions, property instructions, general instructions, contravention instructions. These practice directions are basically a how-to guide for the court itself, how the court intends to run those cases. So that's really helpful to know about. A big change that came from that is, I don't know if you all remember the lawyer cat when a lawyer turned up in court and had a filter on for a cat and couldn't turn it off, and the judge was very calm about it. The lawyer was mortified. Basically, now we do a lot more online hearings. So we try and make sure not to use filters. That's not really appropriate. But Online hearings have been a really big change for lawyers and for clients. And you might find yourself helping people who are really scared about going to court, just going to a building, and being able to tell them that, look, it could be an online process. Most of the appearances for court would be in your lawyer's office or dialing in just like this. Which takes away some of the fear, I think, for a lot of people. So that's a really big change from what people are used to, but that's something that we're all dealing with now. So now when we talk about what's new in family law, the most recent changes, on the 6th of May, the first tranche of changes actually came into effect. So the law changed, and this change is mostly focused on parenting matters. So that's why our presentation is focused on parenting today. The law changed in relation to what parental responsibility arrangements should be if parents are separating and a court has to make a decision, and how the court actually decides what is in a child's best interests. The law also put in place some new provisions for independent I'm getting tongue-tied there. Independent children's lawyers, so we call them ICLs, and family report writers, people who write reports that help the court decide what arrangements should be in place for children. The update also included what happens when someone breaches the orders. So if someone does not follow the orders that they've been ordered to follow, what happens to them. There's a new provision about harmful proceedings, people starting cases over and over again. Safety information, basically sharing information between agencies that have information that affects people's safety, and also just clarifying the punishment for people who post about parties and cases online. We call it publication of proceedings. You're not allowed to do it, but you often find people posting things on Facebook, for example. That's just really not allowed, and they've updated it to make it really clear that that's what's happened. But there are some further changes coming in. So whilst these changes about parenting and the current arrangements are the first set, there is a further set of changes coming in, which are going to be focused on property division, so that financial division as well. So I'm going to talk a little bit about that. On the slide, you'll see that there are two pieces of legislation: the Family Law Amendment Act and the Information Sharing Act as well. Those are the pieces of legislation that brought in the changes. I'm not going to go through them, but that's helpful for you to know, I think. What I think is more helpful is for you to actually hear about what those changes are. So first of all, starting with the information sharing, because that's easier to explain and a bit shorter. Basically, when the department and police have information that is relevant to the court, there was always a pathway where you could request that information, but that pathway was usually a bit sticky. So now there's a new pathway about sharing information about family violence, any child welfare concerns, and even gun licensing between the state authorities and the court, so that it's really accessible and quite admissible in parenting cases, because that information is really relevant. So the court needs to know about those safety issues to make sure that not just kids, but all the parties involved are going to be safe. Legal professional privilege still applies. So that basically means you're not going to be getting lawyers to say what their clients have told them about things. People were a little bit worried about that. But essentially what this part of it means is that the records about safety issues, the things that you might as support workers actually be making reports about, are going to be, or should be, heard in family law cases. Now,
so Shada, sorry, before you go on, I'm just going to put a link to a document it's in the chat, you'll find it, and that's a link to a summary of the law that changes to parenting. So you don't need to look at that now, but that's just something for you. It'll also be in an email you get later on with all the links we're talking about today.
Yes. So as we come on to that parenting side of things, a lot of people in the past used to think that parental responsibility, which actually means decision-making powers about children, if that was shared between parents, they used to think that shared parental responsibility meant equal visits and time arrangements, 50-50, you might have heard it called. That was never the law, but people thought it was the law. So it used to cause a lot of confusion, a lot of distress for parents who thought that that was what they were entitled to, or that's what they should be agreeing to. A lot of confusion for professionals working in the area, trying to explain that that's not what the law actually says, but that's what everyone sort of believed. So that presumption about parental responsibility is removed. Basically, the court can allocate, as it used to be able to as well, but the court, it's now really specific that the court can allocate sole or joint parental responsibility. And it's really talking about decision-making capacity now, decision-making powers. And that's the language that we're using now. But the court can give it to one parent or both, or others involved in the case if need be, about kids based on what's in their best interests. So if there are no orders in place, if you're talking to someone before they've gone to court or they don't need orders in place, it does remain to be shared between parents. And parents are encouraged to consult each other in relation to the decisions they make about kids. But the changes to the law have really emphasized safety. So safety is a really big deal. And that's forefront in a lot of things. So if there's any safety issues, then that's what the court's going to be considering as well. The law actually has been updated to state that there are two objects to this section. So when we're talking about what is the point of this law, it's to ensure children's safety and comply with our United Nations, with our obligations pursuant to the UN Convention on the Rights of the Child. We signed up to this, and United Nations conventions operate in a very big sort of international way. And then when we want them to apply in day-to-day life, we have to put them into our day-to-day legislation. So that's what this change basically is trying to do. So the brochure that the fact sheet that Natalie talked about, that's now attached in the comments section there that you can download, is my little summary of section 60cc. So this is the section where the courts actually say, this is what we're going to use to work out what's in a child's best interests. For my clients, when they come to see me, I talk about this as saying, look, this is what a judge will think about. So you should think about this too. You don't need to go in front of a judge to make your own decisions. You may come up with your own agreement, but it's important for you to know what it is that a judge would be applying if they were making that decision. So you can think about those things too. The law, that fact sheet actually has the actual legislation, so you can read what the law specifically says. This is my reinterpretation of it because there are a lot of words in that legislation. This is my short version. So basically, 5 main things. We're going to look at what's going to keep a child and their carers safe from harm and family violence and abuse or neglect. And we've got to look at the past history of harm, including any AVOs or any violence orders at all, and the history of what's happened in the relationship, as well as what's happening currently. We look at the child's views, the developmental, psychological, emotional, and cultural needs of a child, and the capacity of any person who's looking for that parental responsibility, that decision-making responsibility, the capacity for that person to really understand and provide for those needs. And then just as the previous legislation had language like this, that we also look at where it's safe, the benefit to the child of having a relationship with not just parents, though, other people who are significant, like grandparents and extended family members. And then there's a catch-all. Anything else that's relevant to the child is what the court will also consider. But there's a specific section that refers to, for an Aboriginal or Torres Strait Islander child, the court must also consider how the orders are going to actually help that child to connect and enjoy with their culture specifically. So you'll find the actual words of the legislation in that document that's been sent out to you, but that's basically the summary of what it is that parenting law looks at right now.
Thanks, Shada. We had a few questions in advance when people registered, and this next section is answering one of those questions.
Forgive me for the little picture, that just makes me smile. So does age matter? Well, it matters if you're a cheese. Does age matter in terms of when children want to express their views? We want to make sure that children's voices are heard, but I'm also very concerned, as are most family lawyers, about making sure that children aren't weaponized. So you know how susceptible kids can be. It's easy to bribe little kids and probably teenagers as well. And then in between, they can become very, very moral about things and see things in a very black and white way. And kids are easily manipulated by adults in their lives. And we don't want them to be forced to say or think that they need to say certain things in support of one parent or another. So we're always looking at the maturity of a child. We're trying to make sure that their voices are heard, but not forcing them to say things Independent children's lawyers often are appointed in cases. So a very young child might say, I want to live with mummy because there's a dog there and I'm going to get another puppy. Or an older child might say, I want to live with dad because he lets me have a girlfriend. Or, you know, when a child is 16 and say, I want to live with this parent because this is what they will let me do. And they said that they can do this and that. Their views will always be an important factor, but not the only deciding factor. So, especially where professionals like yourself might have some concerns about safety arrangements, that's important to be expressed. Um, but as you saw from that section previously, when section 60cc, it's child's views are one of the factors, but a lot of the other factors really focus on safety as well. So a child may say, their view might be, I want something that everyone else can see is very unsafe. That doesn't mean that that's necessarily going to be what is ordered. It really depends on the circumstances and the maturity and understanding of the child who is expressing those views as well. So the lawyer answer is, it depends. But I really do think age is a number that people get hung up on. What if my kid is 12? There are other jurisdictions and other areas where kids' voices are a lot more definitive, but in family law, it really just depends. Okay, so I mentioned independent children's lawyers. So like I said, under the United Nations Convention, we really want to try and emphasize that kids' voices should be heard when we're making decisions about them. But we are worried about making kids feel that pressure. Kids are under a lot of pressure in the world today. It's not the easiest place to grow up, and we don't want them to have extra anxiety put on them just because the Family Law Act says that their views should be heard. We don't want them feeling guilty because they say one thing that mum hears about that dad didn't like, or that, you know, their friends say that their parents do this. You know, kids pick up a lot of things from a lot of different places, and they're still growing, and it's our job to keep them safe and protected. So one of the changes that's been made is that independent children's lawyers, if appointed in a court case, should meet with the children that they're speaking for and about. You may be surprised that that's not already the case. In New South Wales, you don't have to be surprised because New South Wales Legal Aid had that process in place already. ICLs meet with children, but where appropriate. For some kids, it's too traumatic, or for some kids, they're too young. But in almost all cases where it's appropriate, that was happening in New South Wales already. But remember, I said family law is a federal matter. So in other states, that wasn't always the case. And in fact, some people said that it was too traumatic for kids to have to meet with another person in their lives, and they preferred not to. But now that's changing to be uniform across the country. So that is something that case law is already being decided about. It's already coming up in cases where people are saying, I didn't meet with the children as an independent children's lawyer, and being told to go back and do so. And just as a little aside, in Hague cases, so international child abduction cases, there wasn't always an independent children's lawyer appointed just because of a quirk of the words in the law, but now it can be, ICLs can be more easily appointed in those kinds of cases. Another thing that's changed with this update is family report writers. The changes give the court the power to make specific rules about report writers, because I know there's been a lot of controversy in the media previously about reports and people being unhappy about the reports themselves or the way that writers have put them together. Rules and regulations are being put together about that. So the law changed to allow those regulations to be applied. The next thing that we're looking at, people had a lot of questions about enforcement, compliance. Basically, what happens when someone doesn't follow the orders? You've gone through all the pain of trying to negotiate, didn't work, go to court, get these orders. Orders are made, and then someone just goes, not following them. That's incredibly frustrating. Now, remember how I said that the law had changed when the courts merged? At that same time, the processes for contravention, which is the legal word about breaking orders, the processes for punishing contraventions actually changed as well. So when the court used to hear a contravention case, it used to get stuck in the main family law case that was going on as well. Now it's changed so that there is a fast-tracked contravention pathway in the court system. Basically, a court would usually not reopen a case to make a change in orders for parenting unless there was a significant change in circumstances. So the law, the case that that we base that on is called Rice and Asplin. So you'd hear about the Rice and Asplin rule. Things haven't changed much, and the contravention case would be running, and there wouldn't really be opportunity to make any difference. So those things would sort of like get mixed up together. What's happened now with these changes in the law that have come in May is that the Rice and Asplin rule has basically been put into the law. So there's got to be a significant change in circumstances, and it has to be in a child's best interest to reopen a case. But if someone is just breaking the orders and you don't want to change the orders, you just want them followed, that is still called the contravention pathway. So complaining to the court about a contravention, when I talk to clients, I say it's like in school when a child is naughty and breaking the rules, they don't get told in private, you've broken the rules. They usually get told in front of the entire class, you've broken the rules and this is the punishment now. You're going to have a timeout for 5 minutes or something like that. Part of that is so that the child knows that they've done the wrong thing and there is a consequence for that. But part of that is also so the rest of the class knows what's happened and gets reinforced that these rules are in place for a reason. So a contravention case is kind of the same way. It's not just saying you've done the wrong thing here, but it's also talking about the value of the orders. If the court doesn't do something to enforce the orders, then what's the point of them being made in the first place? So this fast track process is actually a pathway that paperwork doesn't get filed as usual in the court online system. There's a different pathway for that. There's a fast tracked judicial registrar, a senior judicial registrar listing that means that they can have someone dealing with it very quickly and putting some consequences in place. If a person has broken the orders, how do we fix that? What's the punishment going to be? And the punishments for contravention range from you missed a weekend, so you get an extra weekend of time, to potentially jail. Like, it is quasi-criminal consequences. So it's a really serious pathway. And so if a client wants to complain about a breach of orders or has a contravention claim made against them, they really need to get some legal advice, because this is quite serious in terms of its consequences for them. As I mentioned before, there's a publication provision. Family law matters are private. There's some thoughts about whether they should be. I mean, does it actually help for people to have more of an understanding of what goes on in family law matters? That's not what we're talking about here. That's a bit of a philosophical argument. What the law says is don't publish details about a case. You can't publish anything to identify the parties to a case. You can't put up on social media and post on Facebook, the judge said this and my ex said that, and I heard about their counseling record saying that they were worried about this. You cannot do that. You cannot use that information to shame people outside, or it's a really private matter, and the court takes this really seriously. So sometimes you might hear about things being published, especially in child kidnapping cases, what we call recovery cases. You might hear news bulletins where the federal police have requested that people notify them if they see certain parents or children outside. That's usually because the court has made a specific order allowing the media outlet to publish that information. They would not do it without that. So general rule, just tell people don't get off social media, or just like vent it to your little diary, but just do not publish or put online any of the information about things. Now, as support workers, this new section is really interesting. A lot of people that I work with, when they're talking to me about how the family law system impacts their clients, a lot of my social worker friends will tell me that it's systems abuse. When someone started court and the court case is finished, and then the other person breaches the orders and you have to take them back to court, and then the other person keeps bringing new applications back to court and draining out money because you make a little bit more than makes you eligible for legal aid, and so you have to pay for a private lawyer and you have to keep paying, and every time they send your lawyer something, the lawyer has to charge you for it, so you're losing money, and it's very stressful and it's very anxiety inducing to know that your ex can just keep filing applications over and over and over again. When that happens, you can ask for a vexatious litigant order. So if a litigant is vexatious, basically doing the wrong thing, an order can be made about that. But it, just like the name is such a mouthful, the process is really daunting for a lot of people. And people, although it was available, just didn't use that opportunity. In the new changes, there's something called a harmful proceedings order. basically a judge can decide to make this by themselves, or a party can ask for it. And what that means is that before someone starts a new case in the future, they have to ask permission from the court to actually start that case. So someone's checking whether it's a legitimate case or not. So if it stresses you out to even hear that your partner is filing a new case, you can say, I don't even want to know. You might just want to know what's going on and say, look, if they try to file, please let me know that that's what they're doing, but you can opt in or out. And what this requires is a finding that a child or a party, your client potentially, would suffer harm if the other party was allowed to start new cases. And that harm can mean psychological harm or oppression, major mental distress, a detrimental effect on the other party's capacity to care for a child, or financial harm. And that harm can be cumulative, basically based on the past history of what's happened. And I think that's really interesting and really relevant for you to know, because that's something that I think you find people saying all the time. I don't want to go back to court. That was such a stressful case for me. And now what happens? And now my ex is dragging me back, and this is going to keep going. And it's 20 years of my life that's been spent in court. The children have grown up and become adults, and we're still dealing with court. So if you've got clients like that, this is a really relevant section for you to know about and to advise clients to come and get some advice about.
Thanks, Shada. I'm just going to pause there for a second and see if anyone's got questions, because from now we're moving on to a few other different things, including the changes that are going to come. So now we've just talked about the changes that started on the 6th of May, including the changes to parental responsibility, ICLs and family report writers, what happens when orders are breached, and the information sharing and the punishment you're talking about just now for unharmful proceeding orders. So if anyone has any questions about those changes, just pop them in the Q&A and we'll get to those. So now, Shada, we've got 16 minutes till 11 a.m. So we'll move on to where to from now in family law. Thanks, Shada.
So basically, I'm not going to go into detail about this, because once these changes come into effect, we will probably do another session. But the proposed changes that are coming in are focusing on property. So clarifying our disclosure obligations and confirming that 4-step process, and codifying canon, which is really interesting too. So disclosure obligations, basically that means in a family law case, when dealing with property, you have to tell the truth and tell all the information that's relevant to the case. So lawyers are going to be told to put extra clarification to make sure that clients really understand that they should be giving all the information that's relevant to the court. You can't hide assets, you can't hide information, and there will be punishments for the clients who do this, but potentially also the lawyers who don't do enough to stop it, to make sure that basically everything is open and upfront. So the words for this coming law have not yet been determined, and these things may still change. So I'm just giving you a shape of it just so that you know what potentially is coming. Remember, I talked about that 4-step property split, working out what's in the asset pool, looking at the contributions, the future needs, and a final division of what's there. That's based on case law. That's not actually written down anywhere. So people, oh, apologies, there's a siren out there. But when people are running their own cases, they can't just look at the law and say this is what the judge is going to apply, like section 60cc, for example. That's not currently in our laws. So actually putting it into the legislation, I think, will be really helpful for clarifying for everyone that this is the way that the law will be applied. Now, one of the other factors when we talk about contributions to a relationship, canon is a case. There's a case that was, it's a bit of an old case now, but it basically said where there's family violence in a relationship, the contributions might be considered to be a bit heavier by one person because of the effect of that family violence, making their contributions harder. So they should get extra percentage, extra weight based on that feature. So when we're looking at what those contributions are, we're recognizing what family violence impacts have on a financial settlement, which is a really high threshold right now to bring up in a case. If you're trying to make that argument, you have to prove a lot of things. But the proposed changes actually might include that as part of the changes. So that's a watch this space, really interesting concept to keep in mind. Now, the process for court, this is only one tiny bit of the fee structure, but you can see an application for divorce is over $1,000 to apply to the court. That's not lawyer fees, that's court fees. Even if you're on a healthcare card, pension card, getting a reduced divorce fee, it's still hundreds of dollars. That's quite a lot of money. Consent orders, where you come up with an agreement by yourselves, that's a couple of $100s too. So for a lot of people, when they're looking at how they deal with family law matters, they see costs for court and they don't even realize that that's not the additional costs for a lawyer to help them. And they just think, I can't afford it. So what do you do in those circumstances? When you're talking to clients, you're probably saying to them, look, I'm going to send you to get some advice from a family lawyer. It's going to be free from legal aid to start with. They might not be able to help you and you may have to end up paying a private lawyer outside, but they'll talk to you about what that is. When you send a client to us, because of confidentiality, we're not going to tell you anything about them. We appreciate the referral, but very politely, we're just going to say, unless the client has authorized it, we're not going to share information back with you. And I know that might sound a little bit rude, but that's our obligations. If the client authorizes it, you can be dialed into a call or sit with the client as well if that's a workable arrangement. But the client has to consent to that. And usually we're not going to allow you to speak for a client. So some clients will say, look, I told my support worker all about this already. Can they just tell you? And the answer is probably going to be no. And I know that might sound a little bit mean, but it's really important for clients to speak for themselves, especially if we're assessing whether, if this has to go to court, can they speak for themselves, because no one else will be allowed to talk for them when they're giving evidence, for example. And it can also clarify certain things in terms of the way that they express things. So that's just something for you to know. But when you're actually making that referral to us, what is it that we're going to do? So for legal aid can do family law, criminal law, and civil law. So that's things like immigration and housing and basically stuff that deals with departments and corporations. So we give free legal advice by telephone. We also see people face-to-face in our offices and also in outreach locations. So I know that I and many of my colleagues go out to your places of work where support workers actually are, and we have clinics in your places of work too, or nearby to you, sometimes in hospitals, in support networks and things like that. We also have duty lawyers. I'm a duty lawyer. I sit at the court to help people who don't have a lawyer. The judges might send someone out to speak to me. People might just walk into court on the day. There are lawyers who take on casework representation under a grant of legal aid that are employed by legal aid as well. And we also pay for private lawyers to take on cases too. We can help with small steps like negotiation and funding for mediations, or funding for a whole court case, including barristers to run a final hearing. Legal aid's not free. We have a merit test, we have a means test, we have many, many tests. And we look at the situation of where if a client is able to be eligible for a grant of aid, we usually ask for a contribution, but based on their actual income and assessments as to what's affordable. And like I said, it's really important to know, because we've got so many different teams, we're firewalled. We can give advice. So if Legal Aid Parramatta office is giving advice and I am at Legal Aid family court duty service at the court, I'm in a different team. So even though the office might be representing the mother, the father can come to me and get full advice without there being any conflict of interest between us. So that's important for you to know too. Don't prejudge that someone's getting legal aid help, the other person can't. That's not the case.
Thanks for explaining that, Shada. I think that's a really common myth about legal aid in family law. If one party's got legal aid, the other party just has to go off on their own. So
Yeah,
that's
and
not
you
the
don't have to
case.
figure that out for yourself. As a social worker, you don't have to figure out where the place is that the person can get advice from otherwise. Just refer them into us and we'll figure it out on our back end and actually make the arrangements for the appointment with the right kind of lawyer for the client.
Okay.
So
So we're going to talk, sorry.
yeah. Well, I was going to say, so how do you refer to us? Law Access. You've heard about Law Access, I'm sure, 1,000 times. It is part of legal aid, and it's basically the gateway to all of the services. And Natalie was going to talk about the chat process for getting advice that way as well.
Yeah, I think a really useful. So the legal aid website was changed last year. So the Law Access website and legal aid websites merged, and it's a really good site now with a lot of legal information. there's the phone number there, 1300 888 529, but also there's a chat feature. So if you go to the website, either on your mobile phone or on a computer, there's a chat button, and that's actually a live person you can chat with. It's not a bot. So that's really really helpful and really unique. I know when I use those chat functions for other organizations, it's very often a robot you talk to first, but that's not the case here. So I think that's really useful for a lot of people who might just want to type rather than make that call initially.
Yeah.
And there's a QR code there if you want to scan that with your phone on the screen. If you're watching on a laptop or computer, you can go straight to the Legal Aid website from there.
Yeah. And that's really handy. I think for some clients, though, you might think to yourself, look, this client is really anxious, needs to see someone face to face, needs an interpreter. What can be done then? They're not going to be able to engage so well with the resources that are there. But we also do have face-to-face appointments. And Law Access will be able to take the information and work out the best way to do that. Additionally, like I said, I'm a duty lawyer, so I'm at court dealing with emergency matters as well. So that's often things like where children are about to be taken overseas without a parent's permission, or needing a recovery order or things like that. We give advice on a duty basis. I'm from the early intervention unit. You don't need to know these names. You can just contact us. That's for sort of like emergency matters. We have a domestic violence unit as well, also doing duty advice and assistance at the courts. If you're telling a client to get some urgent advice from the court because some emergency is happening, just let them know that we call from a private number, because there is usually no other way. We need to know the name and date of birth, and that's for conflict purposes. If I've advised the mum about stopping someone from taking a child overseas, the dad can't come and get advice from me at the same time. That's just not okay. So they need to get advice from someone else. So that's why we need those details. I know it's painful to have to provide them, but if you're making that referral, you absolutely have to give that information just so that we can do the right thing. If it's not an immediate emergency, then an appointment in the legal aid offices or by telephone or at a particular time or place is probably going to be more appropriate. But for emergencies, the duty lawyer contacts are up there on the screen. At the courts, we also have family and advocacy support services. So that's specific men's support and women's support services at the court. You as support workers are probably already aware of the kinds of supports that clients need, but sometimes they just come in straight to a lawyer. These services are also able to be with people during their court cases, so provide a safe space for someone to sit. It's kind of like WDV CAS for the AVO local courts, but this is both for men and women, separate services at the family law courts. So their phone numbers are up there on the screen. And like I said, as duty lawyers, we're available for emergency matters as well. And in terms of resources, so we mentioned we use interpreters, telephone interpreters where needed, and also face-to-face. But what we do is we also have a number of fact sheets and resources that are available on our websites. You can see the do-it-yourself divorce kits. Some of the things that we tell clients are, look, you may not need a lawyer for this. There's a guide step-by-step as to how to fill out these forms and what you need to write in your affidavit, fill in the blanks. And we can actually give them that information, that brochure, and help them sort of see what it is they need to do. The Attorney General's website actually has a lot of information. So when it comes to fact sheets about this presentation, I didn't want to reinvent the wheel. The Attorney General's department has a short 2-page fact sheet for parents and a 6-page fact sheet for lawyers. And I think you guys as support workers really should probably get the 6-page one. Get them both. It doesn't matter. It's all online. And the Attorney General's department has actually translated quite a lot of these for parents. So it's in a lot of languages, which is really great. For legal aid, we're in the process of updating our resources. So because the parenting laws have changed, we've updated part, but because the property laws are going to come in, we don't want to have to pulp a whole heap of fact sheets and brochures and reissue them, and you won't know what the last one was and what the new one is. So we're kind of holding back a little bit in terms of reissuing a whole heap of new publications, but keep an eye on our website. New publications are coming up all the time.
Thanks, Shada. And all the links that you could see on the screens, they're all going to be in the email that you'll get after the webinar, so you can go straight to those.
Oh, that's
something
right.
A bit different.
Before I forget, this is something that's really important to me. It doesn't really fit with this presentation at all, but I want to tell you about it. Support workers are shocked every time I tell them this. So anyone can search your details on the electoral roll. As lawyers, we send clients when they're looking for their other party so they can serve paperwork, serve their divorce and so on, to go and find details from the electoral roll. That's part of what we do. People can find your details there too. So if you're supporting someone, if you're dealing with family violence cases, if you're trying to help clients keep safe, think about your safety too. It might be worth you thinking about whether you want to become a silent elector, go on the silent roll. So it was a 5-minute process for me. It didn't require a lot of information, just the fact that I was working in this area and this is something I thought was needed for my safety. I encourage you to think about whether this is right for you too. Just want to let you know.
Thanks, Shada. So that's the end of our presentation. The email address you can see on the screen is if you or your organisation wanted more information about these family law changes or any other area of law, you can contact our community legal education branch and request an information session for yourselves. So also, if you have any comments or feedback, you can email us. You will get an email. I think it gets sent tomorrow with all the links. And we can stay online, Shada, for a couple of minutes if there's any questions. Thank you, everyone, for attending today and for your participation. We don't have any questions yet, so I'm assuming that means you covered everything thoroughly.
I've astonished you all with the thorough coverage that I've given. No, you may come up with questions later, and just as I tell clients, you may think about it and then say, oh, I wish I'd asked. Feel free to get in touch if need be. We're always happy to help. Okay, somebody has said they do have a question, so we can definitely just wait for another couple of minutes. Perfect timing, Shada. Well done. Not often said, but thank you.
All right. I think it's a matter about that contravention where the other party hasn't followed the order, because she said is very common. I think the person's just typing in bit by bit, which is a good way to do it. Just keeping an eye on other questions. I don't know if you can guess the questions. So this is a case
I could
where
talk about
somebody's where the application, contravention application has been filed
because of someone doing something wrong, which they've now taken back. So remember how I said it's kind of like when you get a child scolded in school because of some bad behavior. It doesn't, just because it stopped doesn't mean it didn't happen. So a contravention application is letting the court know that an order has been broken, because the court doesn't know. A judge doesn't come home with a person and say, hey, how are those orders going? The court doesn't call you after a year and say, hey, are those orders still working? No one knows if the application is not filed to let the court know that there's been a breach of orders. So in the circumstances where someone has changed the behavior or fixed the problem, a person might say, look, I'm happy to not take this back to court. I don't want a punishment. It's all fine. But a person might still say, I just want the court to say to that person, I don't want big punishments. I'm okay for it to be a smaller punishment. There's things like fines and bonds and all sorts of ranges of consequences that the court can tailor to the situation. And usually someone might say, oh, I didn't realize that I was breaching those orders, but now I know, I promise not to do it again. And the court may or may not believe that. But if they do, and you bring another contravention application, it's a fast track process now. It might even be the same person that you're in front of saying, I remember we were here last year and you said that you would not breach these orders again, and yet here we are. There's evidence to say that you've breached. The consequences get more and more severe. I mentioned jail time. Jail time is at the very high end. It's very rare. It's really not common, but it's an option. It's a possibility. So it's just something to bear in mind.
I think this is a question about partially responding. Like it sounds like the contravention was around posting information about the case on social media, and most of the posts were removed, but there's still 2 there. still on social media. So it's like partially rectified.
So I'm not sure what the question is on that, but I mean, the thing is, the court doesn't go investigate. So if someone wants to bring an application, you've got to bring the evidence too. And remember, because the consequences are severe, the evidence has to be watertight. So you can't just go, look, using common sense, you know that this is the person who put up these things and this is what it's about. You might know that. You might know it deep in your heart, but can you prove it in court? That's one thing. So I think there was another question
I think
that I saw as I
that question
scrolled
might
down
be,
asking
it's
about
a bit too specific. So a couple of other questions are, is contravention order easy for an individual to file, or do they need to go to a lawyer?
it's probably, due to this new process, it's probably easy to do, but I would strongly advise someone get advice. And there are so many places that people can get some free advice about the process and what it means. And I advise this because sometimes people say things like, my ex took the baby and went up to Queensland and is now refusing to ever come back. I filed a contravention. Well, yes, you could do that and say the order's a breach, but really, as a lawyer, I would say we file a recovery to recover the child right away. That would be even faster and get the federal police involved and all sorts of other things. So the reason for advising about legal advice is because of those consequences, and there's also a costs consequence. So perhaps this might be the thing that the other question was coming to. If you make a contravention claim, if you say that someone's broken the orders, but you can't prove it, there may be costs consequences, as in the legal costs of the other person for having to fight the case where you couldn't prove something had actually happened may come back onto you. So if a registrar is asking you to think about whether you actually want to run the case, that might be because of the potential costs consequences to yourself. If you are not successful, are you going to have to pay anything because of the other person using really expensive lawyers to fight the case? These are the kinds of things where on a one-on-one, we'd actually talk about the pros and cons of what could be done and the likelihood of whether that might actually be a reality. Because for some people, it might not be, but for some people, it might be. So yeah, I think when it comes to contravention, good to get someone to get some advice about that process, but they can do it for themselves, but always good to get some advice from a lawyer, just because there are some particular quirks in that area.
Yep. So a bit hard to go into the specific question today. We're a bit over 11 o'clock now, but one final question is around someone's interested to know when those next changes to property might be happening. Do you know,
I have
Shada?
to say, they talked about it being shortly after the parenting changes, which was May. But my entirely unauthorized speculation is I think it's going to be next year. I don't think it will be this year, but you never know. But I don't think so. I think it's going to be a little bit more time.
Okay. All right. Well, I think that's all the questions. Yeah. I think you've given some good background to that very specific question. I don't know if we can go into the specifics today, but thank you. We're going to close the webinar now. Thank you, everyone, for your participation, and have a great day. And thanks so much, Shada. We'll see you next time. Talk about property changes.
Yes.
Thank you very much. Bye, everyone.
Bye.